Well, I'm happy to introduce our next speaker of today. Once again, I make it short due to us lacking us behind the time. Our next speaker is Bettina Steible. Although she's carrying a very German name, she's genuinely French, has been living for a while in Barcelona, and is working as a researcher and lecturer in constitutional law at the Autonomous University of Barcelona since February 2013, as well as a member of the Center for Human Rights Studies of the Consolidation Research Group, European Constitutional Law and the Fundamental Rights. Bettina is going to speak to us about externalizing European values, the case of international humanitarian law. Bettina, you've got the floor.
Good morning, everyone. Well, thank you very much for the introduction. And first of all, I would like to thank everyone for this wonderful seminar. I would like to thank especially the foundation, the Yuste Foundation, for giving me the opportunity to be here and to present this contribution on externalizing European values, the case of international humanitarian law. I don't have slides, so it will be an old-style presentation. I'll try to make it clear so that we do not miss the slides. So, first of all, I would like to say a few words about international humanitarian law. International humanitarian law, which I will call IHL, is the law that applies in times of war. And it is the law that regulates the conduct of hostilities on the one hand, and it's also the law that provides protection to people who do not participate in hostilities. We call them people hors de combat, people who do not participate or no longer participate in hostilities. And in 2002, an article was published on how the European Union has entered into the sphere of international humanitarian law. And it has done so through the Common Foreign and Security Policy, the CFSP. And nowadays, some scholars argue that international humanitarian law has become a driving force, the European Union has become a driving force of the implementation and development of IHL. However, a few decades before, this question was not even imaginable. Well, because, as you mentioned before, when we talked about the European communities at the beginning, we were talking about the Europe of economics, and it was opposed to the Europe of human rights embodied by the Council of Europe. So at the beginning, really, the European communities and later on, the EU didn't really have much to say about IHL. And furthermore, a project on European defense was rejected in the 50s, in 1952. And therefore, there was really no reason for the European communities to interfere in that area. However, as we all know here, European economic integration advanced very much to the point that we had to have an answer also on the political side. We had to democratize and politicize the European communities and European Union. And one aspect of this politicization of the European Union is the foreign policy. So this is how we had the Common Foreign and Security Policy in 1992. Nowadays, even though the European Union is one of the first economic powers in the world, we still have this difference regarding its political power. And sometimes we refer to the European Union as an economic giant, but also a political dwarf on the international stage. And we have to admit that so far, even though it has advanced very much, we have not achieved such a political integration so that the European Union is able to speak with one voice at the international level in a consistent manner. So within that common foreign and security policy, international humanitarian law has become a distinctive element of the EU's action. And it has made use of the CFSP to call for the respect for IHL. And those calls to respect IHL actually reflect the Geneva Conventions. So the Geneva Conventions of 1949 are, let's say, the most important conventions on IHL, on international humanitarian law. And in those conventions, we have Common Article 1, which stipulates an obligation to respect and to ensure respect for IHL. So when we say that state bodies must respect IHL, this is pretty straightforward. If you ratify a treaty, you're obviously supposed to respect it. That's very basic. But we also have this aspect to ensure respect. So what does that mean? Well, there's been an important evolution, and nowadays the meaning that is provided to this aspect to ensure respect for IHL means that we have a decentralized mechanism of compliance whereby all states of the international community are guardians of IHL. And this is so because we do not have a centralized mechanism of compliance. And this is in opposition to some human rights treaties, for instance. So since we do not have this centralized mechanism of compliance, all states have the duty to take all the necessary and also reasonable measures to make sure that the other states also respect IHL. So for instance, if we have an armed conflict, let's say in Syria, and the warring parties violate IHL, the other members of the international community must adopt measures to try to pressure the warring party so that they actually respect IHL. Obviously, we're talking about an obligation of due diligence, best efforts obligation, because we cannot realistically expect third states to have that result, to have compliance. But they must do everything they can so that the warring parties actually respect IHL. And so the content of this obligation is divided into 3 dimensions. We have prevention. So this will take place at all times through trainings, through promotion of ratification of treaties, etc. Then we have reaction during the armed conflict. So we see that one of the parties do not respect IHL, therefore we will try to adopt measures to make sure that the warring parties abide by IHL. And then we have the third dimension, which is after the conflict, on punishment of perpetrators. And this is also why I was interested in that question with you. So once the armed conflict has occurred, state parties to the Geneva Conventions must also adopt measures so that perpetrators, war criminals, are prosecuted. So this is the general background at international level. And actually, at EU level, this commitment to IHL, to Common Article 1, was formalized in 2005 through the adoption of the guidelines on promoting compliance with IHL, which were further updated in 2009. So here we can see that the guidelines constitute some sort of transposition of Common Article 1 into the EU legal order. But what am I interested in here, within this context, the context of this seminar, is how this connects to European values. Because there are no express references to IHL in the treaties, in the founding treaties. Therefore, the European Union has no express competence to act on this matter. However, what I want to say is that there is an implicit codification of IHL through the values of the European Union as they are provided in Articles 3 and 21 of the Treaty on the European Union. So this is by reference to the concepts of rule of law, human rights, and respect for international law that there is an indirect reference to IHL. And therefore, by this means, we have some sort of implicit codification of IHL. Therefore, when the EU implements this obligation to ensure respect for IHL at international level, this derives from international law, but also from the values of the EU. And therefore, this is a manifestation of the externalization of the values of the EU. So I will divide the presentation into two parts. In the first part, I will make this connection between IHL and the founding values of the EU and how IHL has become a founding value that guides the external action of the EU. And then in the second part, I will talk about, well, I will give some examples of practice. And this is important from a legal perspective to give examples of practice. Because first, we want to know whether commitments are actually translated into action. And also because this is one of the elements to have customary international law. So first, IHL as a founding value of the EU. So normally, if we look at the Geneva Conventions, the European Union cannot be a party to the Geneva Conventions. And this is the case because ratification is open only to states. And so far, the European Union has not become a state. Therefore, it cannot be a party, even though it has international legal personality. And also, as I said before, there are no direct references to IHL in the EU founding treaties. And actually, there's been attempts to include references to IHL in the founding treaties, promoted mostly by the ICRC, the International Committee of the Red Cross, but they have been unsuccessful. And the Lisbon Treaty has not filled in this gap. However, first, it can be argued that the references to the more encompassing concepts of peace and security and international law include IHL. So those objectives of peace and security are codified in the treaties. And why am I establishing this connection? Well, because international humanitarian law, the respect of international humanitarian law actually contributes to international peace and security. And this is also observed when the treaties refer to, and I'm quoting, the strict observance and the development of international law, including respect for the principles of the United Nations Charter. So here, the European Union itself assigns itself the mission of respecting and developing IHL, and it considers itself both as an active and passive subject of international law. Therefore, if all of those elements are read together, we can see a connection between the law of international peace and security and IHL. And also, this has to be read in the light of the movement of convergence of IHL and the law of international peace and security. So when I'm referring to the law of international peace and security, I'm talking about the law developed by the UN. And at the beginning, the United Nations wouldn't talk about IHL, because if they would talk about the law that applies in times of war, it would have meant that they would accept their failure. They failed to actually maintain peace. But in the light of reality, they had to embrace IHL. And now the situation nowadays is that the UN has largely embraced IHL. So this is why we have this movement of convergence of the law developed in New York, in the UN, and IHL. And one of the most important manifestations of this movement of convergence is the fact that the Security Council may act, it may qualify some violations of IHL as threats to international peace and security. And when it does so, it can do so in accordance with Chapter 7 of the UN Charter, and therefore it gives very important powers. And the Security Council has done so on different occasions. It has even authorized the use of force to enforce, to ensure respect for IHL, most notably to protect civilians. So this is very clear. We have this connection between international law, peace and security, and IHL. So that's one way. Another way, which is probably more important at EU level, is the vector of human rights. So human rights, as you all know, is one of the founding values of the EU. And the European Union has used its policy of promotion of human rights to actually call for the respect for IHL. This approach was made very evident in a declaration made by the presidency on the occasion of the 60th anniversary of the Geneva Conventions. So here I'm quoting. Here, this is not, I'll talk about this later. So human rights are closely tied to the principle of human dignity, and the principle of human dignity also applies in times of war through IHL. So here there is one connection. And the use of human rights in IHL and vice versa has been made very explicit in the case law of different international courts, so international criminal courts, but also the European Court of Human Rights. So in the case of the European Court of Human Rights, IHL has been used to interpret the convention. So here, again, there is a convergence between the body of IHL and the body of international human rights law. And in this context, when the EU has had to talk about situations of violations of IHL in third countries, it has associated IHL and human rights. And actually, this is pretty logical, because it would be surprising that the EU would say, oh, in this particular situation, so let's take the example of Syria, because this is something that is taking place today. It would be surprising only to talk about violations of human rights law and not about violations of IHL. So this is how it started. And at the beginning, it was quite chaotic, but in the end, it has become more formalized. The declarations have been more technical, and they have referred to very specific principles of IHL. So the result today is that the EU treats the promotion of IHL as a subcategory of its promotion of human rights. It's a subcategory, but an autonomous one, and it often recalls that those are two separate bodies of law, but yet we include IHL as one of the elements of the promotion of human rights on the international stage. And finally, another connection that can be made with the EU founding treaties is the connection between IHL and the rule of law. So in different documents that refer to IHL in the EU context, it is explicitly stated that the promotion of IHL is one way to ensure the rule of law. So this is really understood in the European view as a component of the rule of law. And so this is where the declaration that I was talking about before appears. So according to the declaration that was adopted on the occasion of the 60th anniversary of the Geneva Conventions, international law, including international humanitarian law, is one of the strongest tools the international community has to maintain international order and to ensure the protection and dignity of all persons. The European Union will do its utmost to promote an international order where no state or individual is above the law and no one is outside the protection of the law. Therefore, again, we can say that IHL can be connected also to the concept of the rule of law as defined by the EU. And this is not trivial because from a legal perspective, the founding values are enshrined in EU primary law. So that means in, if I may call it, the constitution of the EU. Therefore, it means that all the policies must be guided by those principles, by those values, and all the policies must also are also legitimized by those values. Therefore, from a legal perspective, this is very important, and this is where we can make the EU action accountable, because all of the policies must respect those values. And actually, the proclamation in the constitutional text of the EU of a space where human rights are respected generates expectations, both at internal level and also external level. So the EU cannot just say, we are a democratic space and then do nothing. On the contrary, it generates expectations. And if we follow that perspective, it must promote its values also on the international stage. Otherwise, it would run the risk of double standards, even though in practice there are always double standards. But still, from a theoretical perspective at least, there must be this basis. And actually, the externalization of the values of the EU is endorsed by the Lisbon Treaty. So if we look at the provisions governing the common foreign and security policy, we see that, and I'm quoting again, the Union's action on the international scene shall be guided by the rule of law, the universality and indivisibility of human rights and fundamental freedoms, respect for human dignity, and respect for the principles of the United Nations Charter and international law. So here you can see that if we, as I said before, in the European perspective, all of those concepts are actually connected to IHL. So this means that IHL must also be promoted on the international stage by the EU. And of course, when we look at the objectives pursued by the EU in its external action, So safeguarding its values, fundamental interests, security, independence, and integrity, consolidating and supporting the rule of law, human rights, and the principles of international law. When we look at those objectives, we see that the EU self-assigns a very ambitious mission. This is almost an evangelical mission to promote its values. So, of course, it is then very hard to meet fully those expectations. But as you said yesterday, it is very difficult also to compare hopes with reality. So we have those standards which are very high, and the European Union at least must take all of the reasonable measures to fulfill those objectives. And I repeat, the inscription in the EU constitutional marble, so we're talking about the founding treaties, entails legal consequences. We're not only talking about moral or political consequences. Those are obviously also very important factors, but from a legal perspective, I'm a lawyer, so from a legal perspective, this is also very important. This has consequences, and this is where we can make the EU accountable. And actually, even before the entry into force of the Treaty of Lisbon, the EU already acted as if it were bound by Common Article 1, by calling for the respect for IHL. And for instance, it was one of the priorities of the EU at the UN already in 2008. And even though, as we said before, the EU cannot formally be a party to the Geneva Conventions, it can adopt a declaration whereby it commits to this body of law. And this is precisely what it did in 2005 when it adopted the guidelines on promoting compliance with IHL. So even though the guidelines belong to soft law instruments, so this is not a legally binding instrument, they embody this commitment to IHL on the international stage. So here this is, I'm going to talk about the second point of the first part. So we have an implicit codification of IHL in the founding treaties, but we also have an explicit mandate to ensure respect for IHL, which is found in the guidelines on promoting compliance with IHL. So very briefly, those guidelines were adopted in 2005. They were updated in 2009. So 2009 was an important year for IHL, not only for the European Union, because it was the 60th anniversary of the Geneva Conventions. So those guidelines do two things. On the one hand, they adapt the institutional means to the already existing operational means that the EU could use in the field of IHL. And also when we think about the moment when they were adopted, it was to foster the dialogue with the US on counterterrorism, because this is the moment when we discovered what happened in Guantanamo, and so the EU entered into a dialogue with the US to try to promote the respect for international law, even within the frame of the fight against terrorism. So this is the context of adoption. However, now they apply to all situations where IHL may be at stake. So we do not have a real legal basis found in the treaties, but in practice, those guidelines offer some sort of de facto legal basis for the EU to act on this matter. Even though they are not legally binding, they represent the commitment of the EU towards international humanitarian law. And they represent a strong political signal that those are priorities for the EU. So when we talk about guidelines, the Court of Justice said that they form rules of practice in opposition to rules of law. So they do not have the same legal authority, but still we have to take them into account. And since they are adopted by EU member states, they represent this consensus of the EU member states. And since they are made for the EU external action, they represent this, this bloc of the EU in favor of promoting compliance with IHL. So for present purposes, it is explicitly stated in those guidelines that the principle of liberty, democracy, respect for human rights and fundamental freedoms, and the rule of law include promoting compliance with IHL. So here, even though we were not so sure about this connection between all of these concepts, it is clear, it is explicit. And therefore, the guidelines frame the EU's action under those values. So what's the content of those guidelines? Well, on the one hand, it recalls very general principles of international humanitarian law. So here I will not really get into the details, but it recalls what international humanitarian law is, when it applies, so it applies in times of war, what are the connection with other bodies of law, for instance, international human rights law. It also lists what are the most important international treaties and conventions. So here it talks about the Hague Conventions, Geneva Conventions. It also refers to the statutes of the different international criminal tribunals, and also treaties and conventions on the regulation of weapons. So this is basically to give an overview of what international humanitarian law is, what it means for the EU. But obviously, those are very vague references. We do not get into the details, and we certainly do not get into controversial questions about the definition of IHL. So it is still an important signal because we have this consensus which is expressed here, but we will not really talk about differences. So this is one aspect of the guidelines, and the other aspect are the operational tools that may be used to actually ensure respect for IHL. So what are those operational tools? Well, we have political dialogue, general public statements, démarches, public statements but about specific situations, restrictive measures and sanctions, cooperation with other international bodies, crisis management operations, fight against impunity for war crimes, training, adopting rule to ensure that arms trade actually is subjected to compliance with IHL. So when we look at all of those measures that may be used by the EU in its external action, we can see that it reflects very much the measures that are at the disposal of state bodies to ensure respect for IHL. So here, the European Union kind of acts like a state, even though, again, it is not a party to the Geneva Conventions. So, obviously, the adoption of those guidelines is a positive element regarding the enforcement and application of IHL, especially when you take into account the fact that we do not have, as I said before, this centralized monitoring system. We do not have a court, an international court in charge of adjudicating on IHL. Therefore, we rely on the international community to ensure respect for IHL. So it is very interesting here to see that the EU intervenes in that field, because it represents 28 so far member states acting as a bloc. Yes, so to sum up, the potential of those guidelines, together with the constitutionalization of the founding values of the EU, has great potential. So here, this is the first part, connection. The IHL as a founding value of the EU, guiding the external action. But what about practice? Does the EU actually implement this obligation? Do we have elements of practice? Is this commitment translated into action or not? So here, briefly, we will see different elements of the EU's practice to prevent violations of IHL from occurring, to react to violations of IHL during an armed conflict, and then to punish perpetrators. So the use of this wide range of measures also reflects the different facets of the EU. And the use of measures will also depend, obviously, on the magnitude of the violations of IHL at stake. So as a diplomatic actor, it uses declaratory policy to promote IHL, but also to denounce violations of IHL. As an economic actor, it establishes conditionality schemes to prevent breaches, and also it can adopt restrictive measures when those breaches actually occur. And if all of those measures are not sufficient, the EU may send crisis management operations. Then, from a legislative perspective, the EU has also adopted measures to support prosecution of perpetrators. So first, regarding prevention, there are different things. So first, we have training. I will not get much into those details, but it is really important to have training not only among the armed forces, but also among the civilian population. And this is particularly important in those countries where we have civil wars, because we don't know whether those people who are civilian will not end up in armed groups. Therefore, it is obviously better to know beforehand the law in order to be able to apply it in those times, which are obviously times of crisis. So training is key. Then we have multilateral diplomacy. So regarding this, this is probably the most visible tool of the EU to promote respect for IHL. So it has used public statements, declarations, which may be issued by the High Representative or by the Presidency. We also have the conclusions of the Council, which may be used to know what is the stance of the EU on a particular element. So the cornerstone of the EU's declaratory policy on this matter may be found in the declaration on the occasion of the 50th anniversary of the Geneva Conventions, so in 1999, because this is the first declaration that exclusively refers to IHL. As I said before, it used to be associated with human rights, and so this is the first declaration where we only talk about IHL. And afterwards, there's been more declarations on the matter, and so now we can cite the two most important declarations which were made in 2009 on the occasion of the 60th anniversary of the Geneva Conventions. So here the European Union renews its commitment to IHL, it recalls the need to respect it, it calls for ratification for those countries that have not yet ratified, especially the additional protocols, because the Geneva Conventions have been universally ratified. So we have this multilateral diplomacy, which is working, and if you look at the website of the European External Action Service, you will see those declarations. Then the EU also acts in different fora. So for instance, we have the international conferences of the Red Cross and Red Crescent. And so in those conferences, from an IHL perspective, this is really important because the EU makes pledges together with its member states. And so it will say, well, this year we will do this. We will promote the ratification of this instrument of IHL. And therefore, this is, again, a way to see whether the EU actually respects its own commitments. And obviously, the EU also makes use of its special observer status at the UN to promote ratification of IHL treaties and conventions. Another way to prevent violations of IHL from occurring is to use the common commercial policy. So through the use of trade agreements in which, okay, I have 5 minutes left, so I will be very brief. So in trade agreements, we have conditionality clauses. We talked about it a little bit before. So basically, the idea is not to provide funds if they can be used to violate IHL, in this case. So the Cotonou Agreement is a landmark in this respect because it has this conditionality clause. And if the 79 states that are parties to the Cotonou Agreement do not respect a certain number of principles, including human rights, including, if we follow the logic that we said before, IHL, it can result in the suspension of the agreement or in the adoption of sanctions. Okay, so that kind of clauses has been included in different international agreements with very different third countries. Then there's also been a policy in the field of arms trade. So, for instance, the European Union adopted a common position. So the idea was that the EU member states could not sell weapons to third countries if there was a clear risk that those weapons would be used to violate IHL. So this is, again, another example. We have measures that are aimed, at least, to end those violations, to put pressure on the warring parties. So among them, we have diplomacy, again. So instead of having general public statements, we have statements about specific situation. In human rights language, we talk about name shaming. So we say this country is violating those provisions of IHL, and we say it publicly. We also have more confidential démarches, and we also have political dialogue. So I gave the example of the political dialogue conducted with the US in the fight against terrorism. We also have coercive measures. So here we're talking about sanctions, the adoption of economic sanctions. Those sanctions can comprise, for instance, arm embargoes. They can include the freezing of assets, and they may be directed against legal or natural persons. And so this has been extensively used by the EU to try to ensure respect for IHL. And it has done so on many different occasions. So for instance, when we talk about Syria, currently the situation is that we have sanctions against the Syrian government, but also supporters, and that includes 235 people and 77 entities. So this is quite extensive. And finally, we have those crisis management operations. So in the case of the EU, we have civilian, well, we always have civilian and military operations. Currently, there are 6 military operations and 9 civilian missions, and of those, only some of them touch upon some aspects of the respect for IHL. So, for instance, there is a mission in Mali to assess the armed forces, so to provide training on IHL, so that there is actually a respect for IHL within that conflict. And I will end with this. The European Union has also adopted a set of measures to support prosecution of perpetrators, of alleged perpetrators. And it has done so by facilitating cooperation internally among EU member states, but also externally through the support to the international criminal jurisdictions, so including the ICTY, we talked about it before, and the International Criminal Court. So to wrap up all of this, even though the EU was not supposed to intervene into that area of IHL in the absence of express competence, the constitutionalization of its founding values sheds a new light on those aspects. And from a constitutional perspective, the respect for IHL is understood as forming part of the EU founding values. Specifically, the concepts of international law, the rule of law, and the respect for human rights. In practice, this is integrated into the policy of promotion of human rights. And this policy fits into a virtuous circle, because first we have IHL, a body of international law established in treaties and conventions. Then we have the EU member states who commit to this body of law. And therefore, this leads to a better implementation of IHL before, during, and after the conflict. In turn, the EU projects itself as a global leader, or at least it aims to be a global leader through the externalization of its values, IHL being one of those values. And therefore, in turn, it reinforces its credibility to act on those matters. And at the same time, EU member states also fulfill their obligations arising under international law. And eventually, we close the circle, and it helps creating customary international law in the field of IHL. So in the light of all of those elements, we can expect the EU to become, we can expect Brussels to become one of the centers of development of IHL together with The Hague, Geneva, and New York. Thank you very much for your attention.
Thank you, Bettina. I don't want to be rude by just reminding you to keep the time frame, but I'm always looking at a countdown over there, which tells me that, well, time is nearly over. Thank you very much for your also very stimulating and interesting paper. I was a bit sort of challenged to remind you when you said, well, EU is not part of the Geneva Convention due to its not being a nation state, but EU is considered to give itself a constitution, which, at least according to a certain group among constitutional lawyers, is also restricted only to nation states. But this is, I'm not going to dig further into this territory, but would like to invite you to ask your questions or make even comments.
Thank you very much for your interesting presentation. I want to say that I really appreciated your point on the role and a sui generis role of the European Union in promoting abroad human rights and the respect for them. Now maybe my question could be a bit outside of your specific research, but if I'm not mistaken, European Union tried to sign the European Convention for Human Rights, and then the Luxembourg court cancelled this because of some problems of EU law. So I would like to ask you, as you said you're a lawyer, I am not, if you want to consider also this in your paper, and if you could, if you have done research on it, say some words on the legal problem on this point.
Thank you very much. Well, as you said, according to Article 6 of the Treaty on the European Union, I'm going to sit here. The European Union is supposed to become a member of the European Convention on Human Rights and therefore accept the jurisdiction of the European Court. And indeed, the Court of Justice of the EU rejected adhesion for the time being because of constitutional issues. And I've got to say that I don't know the details of those constitutional issues, even though I know that it seems like this is more a protectionist approach than really a constitutional problem. So it seems that in the light of the opinion of the court doesn't really want to be subjected to the jurisdiction of the European Court of Human Rights. But they still are working on the membership of the European Union to the convention, so we hope that eventually it will work. But in any case, we already have a very important integration of the case law of the European Court of Human Rights into EU law, because, as I said before, it is included in Article 6. So when we talk about human rights in the EU context, we refer to, obviously, the Charter of Fundamental Rights of the EU, but it is quite new. We talk about the constitutional traditions of EU member states and the European Convention on Human Rights and associated case law. Therefore, well, it is not new. The Court of Justice of the European Union has very importantly integrated aspects of the case law of the European Court of Human Rights. So when we talk about IHL, the thing is that since the EU is not a fully complete global actor, because it doesn't have its own military, it depends on member states. Therefore, the application of IHL itself to the EU is not quite here. But we can expect that if there are evolutions in this sense, and probably there will be, maybe the Court of Justice of Luxembourg will have to apply aspects of the case law of the European Court of Human Rights, even in relation with IHL. I don't know if I answered everything. Yes?
Thank you, Bettina, for your interesting presentation. I'm in particular interested in the second part of your presentation, namely when you speak about well, how the EU reacts to violation and punishing of the perpetrators. So I'm just wondering, you know, whether you're familiar with the efforts to create the EU transitional justice policy. Yeah.
Transitional justice policies is not really my field of expertise, because I deal more with...
Okay, but maybe on that note, but not directly on that case, can you tell me how the EU actually uses its experiences, its know-how in dealing, you know, preventing and dealing with the crimes and violation of gross human rights in practice?
In practice. No. Okay, so regarding prevention, in practice, we have trainings, for instance, and those trainings are often conducted in association with the International Committee of the Red Cross, which is the big institution in charge of IHL. So they conduct trainings within the EU, but also in third countries. And they also do so together with EU member states. So depending on the priorities of EU member states or interests of EU member states, they will work together with some of them in third countries. So that's one way to do it. Regarding prosecution, the European Union adopted measures to establish the European Network on Genocide, which is integrated within Eurojust. And so here we have delegates from among all of the EU member states. And there, they meet, they share experiences, they also make research regarding the legislation, how can it be improved. They also support the establishment of specialized units within tribunals, but also police forces, in order to apprehend and then prosecute alleged perpetrators. And this is very important because, as you know, those are very special crimes. When we're talking about war crimes, we need the expertise of specific persons, because we cannot treat a murder which has been committed within the frame of an armed conflict as an ordinary murder. Therefore, this is why the EU pushes forward the establishment of those specialized units. And some of them have been created, for instance, in France. There are specialized units. Yes.
Just the EU experience of their...
Stop, we need the microphone.
Sorry. But can we really say that this is only the EU experience, because EU has been, feeding from the experiences of UN as well? Mm-hmm. So when I'm saying about how they use these, previous experiences, I mean about, dealing with their experiences in Rwanda, in Bosnia and Herzegovina, and they have been doing this job side by side with the UN. So, how this experience of what the EU forces, EU experiences in diplomacy, in promoting stability, promotion of human rights, how this, actually reflects in Libyan case, for example. Case in Libya, or, in Syria, or, in different cases.
Well, I'm not really sure I grasp exactly what you want to obtain.
Do they use a specific set of tools based on past experiences, and they apply the same tools to different cases,
Well, the tools that they use are the ones that I mentioned before. So it can be training, it can be those private démarches. It can be also the adoption of the sanctions. So in the field of IHL, those really are the measures that are used.
Okay, I will give you another example. Just interrupt me if I'm boring. For example, recently in Macedonia, there was an interruption in the parliament, and blood was spilled in the parliament. There was a lot of issues there. And the day after, Mogherini, she was saying, like high authority, she was saying, yes, we promote the stability and peace in Macedonia. But, the downside of this promotion of stability in the region on the borders of the European Union is that they are consciously selecting certain political actors, and for sake of continuing to dialogue with that same actors, a series of serious breaches of human rights are, I'm not saying ignored, but, left on the margins at the time being, So this is one of the cases, when, there is an interest above, the human rights discourse.
Yes, well, obviously, so since I'm a lawyer and I want to talk about IHL, how it is promoted, I don't remember what I wanted to say, sorry.
We can discuss it later.
No, that's fine. It just came back. So I identified what are the measures that are existing under the current legal framework and whether measures are actually implemented. In some cases they are, in some others they're not. And obviously here this is where double standards arise. And I think that this is quite inevitable because we're talking about foreign policy issues, and therefore we also have interests. And unfortunately, the law, and in this case the law applying to IHL and human rights, is not the only factor that is taken into account. So obviously, in many cases, there are problems, or we decide that, okay, we will ignore those violations, but in return, we know that we will have those inputs. So therefore, we will put this aside for a moment, and maybe later on we will deal with it. But I think that this is inevitable when we're talking about foreign policy, especially when we're talking about the expression of 28 member states. Obviously, in some cases, some member states will want to push forward so that we actually put more pressure so that IHL is respected, and some others will say, yes, but I have interest there, so we will have to be more cautious. Yes, of course, it exists. This is one of the big limitations of this system, because we do not have decentralized mechanism, and therefore we rely on the goodwill of the different actors. This is problematic, obviously.
Actually, on the same line, my question was on the same line, because you spoke about prevention, but also the mechanism, and I was thinking the follow-up, how you follow up these mechanisms, how they work. Yeah, okay, and yeah, I was thinking, for example, because examples that I know, the list of countries which shouldn't be sell.
Yeah. Weapons, for
instance.
Weapons,
exactly. And Mexico, a few years was a case because since 2006 there have been a lot of killings there, and Germany and Mexico wanted to sign a contract to sell even more weapons, and then the 47 students were killed. A really known case with German weapons. So that was like how in the same year they're signing this contract while this case is happening. So the human rights movement in Mexico were trying to convince Europeans and Germans not to sign this agreement because they couldn't do it with Mexican government. So how exist mechanisms to push on that level, or?
Well, regarding specifically arms agreements, so we have the common position that I talked about before, according to which normally EU member states shouldn't sell weapons to those countries where there is a high risk, a clear risk that they will use those weapons and violate IHL and human rights. And the problem is that even though this is an act of the EU, it is excluded from the scope of the jurisdiction of the Court of Justice of the EU. So the Court of Justice of the EU cannot condemn any state for non-compliance with the common position because it doesn't have jurisdiction on this issue. So here, this is very, very important problem, and also from the perspective of the rule of law, because we have some acts which are enacted by the EU, and they are not subjected to the jurisdiction of the Court of Justice. And so here, in the end, the mechanisms of monitoring that we have are more informal. So for instance, the European Parliament issued resolutions and reports on this matter, on the implementation of the common position, to highlight, first discrepancies in the interpretation of the common position among EU member states, because some member states will interpret the requirements in a strict way, some others will interpret it in a more laxist way. So that was one thing, and another thing was indeed, we have a list of countries where weapons have been sold, and we know that the weapons afterwards have been used in violation of IHL. So this is the case, for instance, of Saudi Arabia. A report was published a few months ago on that, and it showed that many EU member states sold weapons to Saudi Arabia, even though we know that those weapons are used in Yemen in violation of IHL. So here, since we do not have the jurisdictional control, we need to resort to more informal control mechanism and also pressure from the civil society. Because even though sometimes we don't see it to be very effective, in some cases it is. And for instance, the French government wanted to sell, I don't remember the exact name of the aircrafts, but those were military aircrafts, and they wanted to sell them to Saudi Arabia, and therefore there was an uprising among civil society to pressure the government not to sell those. And in the end, it worked, but it was once. And of course, this means that we have to have visibility. If we don't know what are the weapons that are actually sold, or what are the negotiations on those agreements, obviously we cannot do anything as members of civil society. But yes, here this is a very important gap.
If you don't mind, I'm going to ask you in Spanish,
okay,
because
no
I
problem.
feel more comfortable, and I know you speak Spanish too, due to your
no
studying in Barcelona. En relación con las herramientas que tiene la Unión Europea para hacer cumplir sus derechos bueno, me espero. I'm going to wait if you want to listen.
Okay.
As regards the EU tools to implement the respect of ILH, you spoke about externalization of certain values. Do you think that is the best way to exchange this for trade agreements? You spoke of conditionalities, but is it important to ask for the respect of human rights and at the same time to allow for tariff advantages, for example, because there are other means like education or training, which may be comparatively better and more efficient?
Okay, well, thank you for your question. I think that there are different elements because, so regarding the first element, can we trade human rights for access to the single market, for instance? Well, but if we turn the question around, then we end up again on the question of double standards. Okay, but if you don't do that, then it means that we give you access to the single market, even though we know that you violate human rights on a daily basis, for instance. I'm just making up this case. But so here we would still have a problem of credibility because we criticize EU member states when they sell weapons to states when we know that they will violate IHL, or when we have evidence that it has happened. So if we do not establish this system, we could apply this criticism also to that area. So that's one thing. And then obviously it cannot be the one and only operational tool at the disposal of the EU, and it must be obviously complemented by all of the other measures. And as you said, education is crucial, it's essential. And in the case of IHL, this is really key because prevention is really the most important aspect of the respect for IHL, because the other dimensions, well, it's too late. It has already occurred. So we really want to intervene before dramatic acts actually happen. So yes, obviously, it cannot be the only one, but it can be one. It can be one among others.
Thank you very much. I would like to speak Spanish as well, if you don't mind.
I think your presentation has been quite interesting and very timely for two reasons. First, one which is a suggestion that I'm not sure whether you have taken into account, because it's not well developed so far, which is that in Article 214.5 of the Treaty of the EU, there is the provision of a Humanitarian Aid Call, which is being debated as a solidarity corps. It's quite controversial, but it could be a line in that direction. Depending on what happens in the next months, it could be one of the practical elements, unless it remains at a level of the volunteer European service, which was allowed to by Professor Corradi. This is quite immature still, but I think it could be a good approach to externalize IHL. Another issue, taking into account the cases you have mentioned in Saudi Arabia, sellings of arms, whether the EU is asking for responsibility for those who have committed those mistakes. We have talked of prosecuting perpetrators, but I'm not sure whether we are giving or making steps to prosecute accomplices or people who may participate indirectly in the omission of giving help or simple actions which are taken without in full knowledge that it is wrongdoing.
Well, so as I said before, since there is no jurisdictional control for those acts, we have a very important gap, and therefore the European Union cannot really act on this matter. What is done is that there are monitoring reports, which are made, I think, on an annual basis. And in those reports, EU member states are supposed to say what they have done in order to comply with the common position. And then on the basis of those reports, recommendations are made in order to improve the effective implementation and application of the common position. But again, we fall again on informal mechanisms of compliance. We do not have legally binding compliance mechanisms. And then regarding the last aspect of your question regarding failure to act, so there is in EU law in general, you can go to the Court of Justice in case of failure to act for the transposition of EU law. However, since there is no jurisdiction, it doesn't apply here. But so maybe if in the future, if all acts of the common foreign and security policy are included within the scope of the jurisdiction of the Court of Justice, then it would be very interesting, because the action of the EU, well, the external action of the EU would be subjected to scrutiny, to jurisdictional scrutiny, so that would be very interesting, but it doesn't look like it will be the case for now.
Thank you. I really enjoyed your presentation about IHL, and I just have a question about how you've talked a lot about the, IHL at a supranational level, like about the international human rights regimes, how they work. And I was just wondering if you could, it's a fact now that there's a gap, that we don't have IHL incorporated in EU policy yet, but what about at a national level, like about the member states, the constitutions of the member states? Are they ready for such a change, or are there conflicts? Are there like we consider the public law, but from the national
Okay, but
side.
So from a national perspective, but with regard to the EU?
Within the member states, like that we would have in the EU. Like,
okay, but so my question to your question is whether EU member states are ready to have something at EU level or simply regarding international law?
No, at the EU level. Like,
okay. Well, when we talk about IHL, since it deals with security issues, it really is at the core of sovereignty, and therefore it is a very sensitive issue. And this is why actually we do not have jurisdictional control over those acts. This is because it touches upon the very core of sovereignty. Therefore, I expect things to evolve at EU level, but quite slowly. And I think that the framework that I presented before is the basic framework of the EU's action. And for the framework at EU level to evolve, we need first to have developments in the field of security. And we know that now France wants to move forward in that field, but we don't know where it will go. So if there are further development there, probably we will have to talk more about the application of IHL to the EU and to the EU armed forces, because so far the European Union hasn't really had to use force, even though we have crisis management operations. But once it will have the power to do so, probably we will have very interesting developments. And hopefully the Court of Justice will have jurisdiction.
Okay, thank you very much.
Thanks for your presentation. I'm not a lawyer. I don't come from the law area, but so my question might sound a bit of naive, but anyway, I'm curious about it. Yeah. When you talk about human rights linked to human dignity, are you talking about human rights as something universal, or human rights as something, let's say, linked to the Occidental heritage? Because if it's the second thing, the question then is, why do we have to externalize it to the outside? And somehow to externalize, that verb sounds me to impose, at least sometimes. And if it's the first, if we are in the first case, if human rights are universal, then, at least from my point of view, the problem is still there. It's just moved. What does human mean? What does dignity mean? Because what freedom or democracy means in one side doesn't mean don't mean the same in another side. So,
okay. Well, that's an interesting question. I will address this question more from the perspective of international humanitarian law, because this is the focus of this paper. So I address those issues from a universal perspective. So this is the first answer. And on which basis? Well, on the basis of the ratification. If we talk about the Geneva Conventions, they have been universally ratified. So all the states that exist on Earth have ratified the Geneva Conventions. So here there is no doubt that there is an endorsement from all of those countries, and that this endorsement is universal. So this is why here there is really no doubt that international humanitarian law must be universally enforced and respected, because all of the states have committed to respect those conventions. And the same actually applies to the Charter, the Universal Declaration on Human Rights. It also, it wasn't ratified because it was a document of the General Assembly, but it was approved by unanimity. Therefore, here again, we have this universal endorsement. And actually, when we look at the documents of the European Union, we can see elements that demonstrate that the EU adopts this universal approach. based on this universal endorsement. So yes, of course, we could say that this is, again, an imposition of European values on the rest of the world. This is neo-colonization. It is just that before it was in a different form, and now we are imposing norms. But in this specific case, it has been endorsed, it has been ratified by all of the states. So this criticism really doesn't stand up to reality. And can you remind me the second aspect of your question?
No, I think that was it, so you answered her. Thanks.
I'm gonna move.
It's
here.
probably easier for me to move. Last night we had a brief discussion, and there is a reason why the waves of migration that currently changes Europe, the European Union, is not part of your paper. But would you say that the migration issue, and I have to admit that I come from a country that has been so to say, highly criticized for its attitude on or towards migration. Do you think that it could can make an impact on the externalization of the IHL in a sense, and highly in quotation mark, would it help your efforts to externalize, to make it becoming a practice? Or how do you see the role of the recent migration in Europe in relation to the issue that you focus on in your paper?
Well, I think that, so when we talk about the law of refugees, it is strictly related to IHL, but it is a separate branch of law. So this is why I do not analyze it. However, I think that from an external perspective, the management of the so-called refugee crisis in Europe has affected the image of Europe, of the European Union as a self-proclaimed leader in human rights and therefore in IHL as well. So since here I was talking about efforts to ensure respect for IHL, I think that not from a legal perspective, but more from a political perspective, and the image of the European Union has been importantly damaged because of the management that has been done of the refugees crisis. And therefore, the president of the ICRC, the International Committee of the Red Cross, said that it looks like when there is one difficult issue, then the EU drops it completely. So they're promoting all of those values, they're implementing many measures all over the world, but then when they are directly affected, so we have this influx of migrants in Europe, then, well, we take decisions in the opposite direction. So obviously, it is problematic, but not really from a legal perspective, but more from a political perspective. And yes, I think that it affects, importantly, the role of the EU as a leader in those matters, of course.
Okay. I think that was it, and well, we've nearly done it in time. Yeah. So once again, Bettina, thank you very much for your presentation, and thank you for your contributions, and I think we've all deserved some lunch for now. Okay, thank you.